A very hearty good afternoon to all of you. Dear students, I hope everything is great at your end. And dear students, we have started the concept of partition, in which we have seen the meaning of partition under the Tashra and the Abhaga school. We have also seen what property is divisible on partition, subject matter of partition, available property for partition, property not capable of partitions. Also, we have discussed in detail regarding the concept of persons who are entitled for the partition and how partition is effected. Right now, today, we dear students, we have to see the concept of partial partition. So, before I start the concept of partial partition, I would like to connect it with the concept of partition. That we have seen that partition is nothing but severance of status of joint Hindu family, which is also known as Hindu undivided family. And through this partition, under Hindu law, the status of joint family is put to an end. So there is a division of property among the members, and the joint ownership of property comes to an end. So for an effective partition, we have seen that it is not necessary to divide the properties in meets and bonds, but under tax laws for effective partition, meet and bonds is necessary. So, so under Hindu law, dear students, a partition can be total or partial. So when we talk about the term total partition, all the members ceases to be the member of Hindu undivided family, and all the property ceases to be a property belonging to said what we call is in Hindu undivided family. And also, dear students, we have discussed that right now we have to discuss that partition could be partial. When I say that partition could be partial, it means that a partial in a sense that through in relation to its members, some of the members go out in the partition and other members continue to be the members of the family. So it may be partial in relation to the properties or some of the properties which are divided among the members of the property of a Hindu undivided family. And so partial partition can take place in two circumstances, which we will be discussing in detail right now with reference to the property and persons. Okay, so we have to see today, I was discussing with you the notion of partition, and therefore I started this particular, what I can say, the introduction. So if a member sues his co-partners for partition, the suit must be compromised of all joint family, which is then capable of partition. This is the common rule. The general rule, undoubtedly, we can say is that there cannot be a partial partition. But at any rate, a co-partner cannot by a suit enforce a partial partition. Partial partition by private arrangement is, however, allowed. And when we talk about the partition, as I told you that there can be total or partial partition both. And in total partition, we know that all the members ceases to be a member of Hindu undivided family, and all the property ceases to be a property of what we can call it Hindu undivided family. So it happens with the relations with the members, and when the members go out for partition and other members continue to be the member of the family, and it may be partial in relation with the property and are divided among the property are divided among the family members. And both the ways it can happen to people, to persons, or to the property, which we have to discuss in detail right now. When partial partition of the joint family is permissible. So even as a rule of Hindu law, if the property is not joint family property and the parties are not the co-partners but only co-owners or tenants in common, the rule is not so rigid and partial partition may be allowed. Okay, and they are the co-owners or tenants in common, which I have discussed in last lecture, which means 30th lecture. if there is no such, we can say, inconvenience to the other sharers. In addition to that, partial partition is prohibited for a good reason, as the partition has the effect of breaking up the Hindu undivided family or Hindu joint family. And if such a family is disrupted, it stands to the reason that the family should break up completely and the whole family property should be divided. So this is the reason and why this particular practice is not appreciated. However, even in suits paying for partial partition have been recognized under the various circumstances. And there are few cases in which these principles have been propounded for the concept of partial partition. Very first case in front of your screen is the case of Hare Hare Singh Chaudhary versus Hari Chaitanya Singh Chaudhary. Second case is Manasha Rama versus Ganesh Manu. And the third case is Panchan Malik versus Shiv Chandra. So where different portion in these cases it was held and these principles came into existence, where different portion of family properties are situated in different strict separate suits for partition for land of each district may be brought in. It may be allowed when the portion of joint family at the time of suit for partition is incapable of partition, where the property left out from its very nature is impartible. The property is held jointly with the strangers who cannot be joined as parties to a general suit for partition. Same may be left out. When the co-owners by mutual agreement decide to make partition of the joint family property, leaving some portion in common. So these are the different instances which we have seen. And right now we have to start the concept. We have to see the concept of what we can call is the concept of partition. So the presumption which is there, the presumption which runs, we can call it, is that there is a presumption that every partition is a total partition. Are you able to get it? And in the case of Divakar versus Prabhakar, the first case on your screen, and in the second case in front of your screen is the Mati versus Phoolchand case. So two cases are there, Divakar versus Prabhakar and Mati versus Phoolchand. In these cases, it was held that there is a presumption that every partition, as I told you, the burden of proof was discussed in these two cases. The burden of proof that there is that the partition is partial or there has been a prior partition is on the party who asserts that it is so. Okay, so the burden of proof lies on the person who is trying to assert that it is so. So in the case of the fourth case, which is in front of your screen, Narsingh versus Adi Kanda. In this particular case, it was held that on partial partition, the family does not ceases to be a joint family. And the joint family and the joint business continues to be joint. Okay? The business will carry on if some co-partners or partners are willing, people are willing, they can make for a partition, but it would exist after partition also. Okay. So the second, the case is Jagannath versus Lalapi. It was held that it is open for the parties to make partial partition. A partition is a question of fact. So this is something which I think that when we talk about question of fact, it is something in which we can say that it is not dependent upon law. Okay, the court will see the matter, the court will decide the matter accordingly, looking after the facts, and each fact, as I told you, is different. Okay. So now coming to the in the case of Lalavati versus Parasram, also it was discussed that a partition may be a partial as to property and also a partial as to persons. So both the ways it can run, it can take place. When we talk about partial as to property, in the Privy Council in the case of Ram Linga versus Narayana in the year 1922, an old case, the Privy Council said that it is open, it is something which is open to the co-partners to, to sever their interest in respect of part of joint, we can say joint estate. Okay, the co-partners are having the power to sever their interest in the joint estate, joint family property, while retaining their status of a joint family in respect of the rest of the properties. Okay, so as a general rule, we can say that no one can impose on others a partial partition. You are doing your partition for yourself. The other co-partners are not allowed to impose a partial partition on others. So no one can impose except the father a total partition on others. Thus, if some co-partners want partition, they are willing, some co-partners, they may, we can say that, and the others are not interested. The others are, they are, while the others do not want it. So who want partition may take away their share and the rest will continue, you can say, to remain joint. They will remain joint. Okay, they are having the right to ask for it and to remain a joint. And also what happens sometimes, a partition may be partial under compulsion to circumstances. There are certain circumstances, okay, and such will be the case when properties are in several districts. So in this particular case of Christia versus Narsimham, it is an old case propounded by Madras High Court, and in which the property was situated in different districts, several districts, as I discussed you last to last slide. District court is competent to effect some partition of those properties which are situated via the different jurisdiction, and sometimes the partition may be partial because of status forbids it so, because of the fragmentation of the holdings of the properties. So in this case of Christia versus Narsimham, it was said that it may be again be partial by the very nature of some properties do not capable of partition, or when state is impartiable by custom, or when some property is subject to the mortgage. Okay, so these are the instances which we can say that in which a compulsion of circumstances is being made. Therefore, the court has propounded or the law has evolved in such a manner, okay, where the properties are fragmented, they are not situated in a particular place, there are certain customs, okay, and mortgage is there. If you will go through the law of property, you will find what is meant by the term mortgage, how we lend money, we ask for the money, and we keep the property for the wealth which is required. So these are the instances, dear students, in which the we can call it a partial, are known as partial to the property. Okay, now we are coming to the other, which is known as partial to the persons, or also called as partial as co-partners. So if one co-partner or a group of co-partners, we can say, want to separate, they cannot impose separation on others. Enter it. Are you able to get it? What I'm trying to tell you. So there is any presumption in law into this particular effect. So the other co-partners are not having the power to impose it on the other remaining co-partners. So in this particular case of Hari Baksh versus Babu Lal, this case is also an old case. In Privy Council in 1924, it was discussed that the fact of separation having been effected among brothers raises no presumption, okay, that there was a separation of joint family constituted and headed by each brother. So brothers, however, we can say that brothers cannot be deemed to be separated from their own sons. Okay, so in this particular case, Privy Council has that the fact of separation. When we talk about the fact of separation, when we say that okay, this is the fact that a sort of a fact, the separation have been effected among brothers. But there is no presumption. If the brothers have been divided, it raises no presumption that there was a separation of joint family. Okay, it was constituted, headed by each brother. So if the brothers are there who are heading their family will exist. It is not so that the whole, we can say, concept of the joint family has been divided. Okay. So in another case versus Palani versus Muthu Venkata Hola, it is an old case. And in this case also, which instead the Privy Council said that there is no doubt that a co-partner can separate himself from the others. So what does it say? That there is no doubt a co-partner can separate himself from others, and no co-partner is entitled to have his share in the joint family ascertained and partitioned off for him, and that the remaining co-partners, without any special agreement among themselves, may continue to be the co-partners. Are you able to get it? So the other co-partners are in a position, they can continue it, and no co-partner is entitled to have his share, the joint family ascertained and partitioned off for him, that the remaining co-partner, without any special agreement among themselves, may continue to be co-partners and to enjoy, we can say, the member of a joint family, what remained after such partition of the family property also the case. So this is the, we can say that things that which have been discussed here. So no express agreement to remain joined on the part of the remaining co-partner is necessary. What in this case it was held. Maybe sometimes the language of the cases are which are propounded are not comprehensive to you. There is a chance, because what happened, these particular decisions have been propounded by the people who are sitting on the bench, and they're very experienced persons. They have read what to say everything, and many a times it becomes difficult for a student to comprehend what has been said. So you should not put down, because they are mature people, 50 years, 60 years age, very wise and experienced. So in this case, what we can say that no express agreement or remain uh, uh, joined on the part of the remaining co-partners is necessary. That they remain, you can call it that joint may be inferred from the conduct as they carried out of their joint business. Okay. So this is what meant by the particular term, and after the separation of the other co-partners. So it is a question of fact to be determined in each case upon the evidence, as I told you. Each case is having its own circumstances, its own facts. Relating to the intention of the parties, whether there was a separation among the other co-partners or they remain joined. And the burden of is on the party who asserts the existence of a particular state of a thing, on the basis of which they are claiming the relief. So in the case of the second case is the Apurva versus CIT case. In this particular case, also, it was held that the father has a power to effect a partition between himself and his minor sons. You are getting it? The father is having the power to effect a partition between himself and his minor sons. He can impose that particular thing on minor sons. Are you able to get it? So these are the, we can say, these are the cases in which this particular thing has been discussed. And also, as I told you, when I was discussing that in these particular cases also, the gist was discussed, which I brought to you. There are a few principles which have been, however, we can say, suits for paying for partial partition have been recognized. Although this concept is not recognized because the property may get divided, the strangers may come in, but we can say in certain circumstances, the court has accepted, and the court has, what we can say, that laid down that okay, partial partition in certain circumstances may be allowed. Is it clear to you? Okay. So we have seen this particular concept of partial partition. Okay. Now coming to the next topic is which is there effect of partial partition. What are the effects? Okay. So on the separation of one co-partner from the other, a question arises to whether the other members are deemed to be joined or reunited or separate. The question depends upon the presumption and also to a great extent upon the intention of the parties. If they are willing to be joined, they would be joined. If they are not willing to be joined, then again the presumption will be that if they have expressed something by their intentions, by their conduct, by their motive, by their intention of express and the things which we have seen and discussed, if you're able to recall the past instances in which we have tried to understand how this particular thing is expressed and how it is communicated. If that particular facts are there, then it is okay that there is an effect for that particular term of partition. Otherwise, the court has to discuss and the court has to see the facts and the whatever finding the court is able to get. Okay, so it is to be seen whether the non-separating members intend to remain joint and to enjoy as a member of a joint family what remained of their property after such partition. So it would be seen that after partial partition, the non-separating members, what they have done, what their conduct was, whether they have carried on to enjoy as a member of the family, joint family, or whatever remains have been remained after the partition, whatever has been left. So these are the instances by which the court will draw the premises. The court will draw the conclusion. Okay. So there is no need of express agreement to this effect. Okay. There is no such need. The intention to remain joined may be inferred from the way we can say in which they continue to live together. Is it clear to you? So however one brother separates from the rest, there is no presumption that the others remain joined. Such an intention must be proved like any other fact. The court decides on what we can say facts. And when you will be reading your procedural law, especially your evidence law, you will come to this particular conclusion. Presumptions of fact, presumptions of law. So facts are something which tells a particular thing. And then by applying the law, the court draws to a conclusion. The court comes to a conclusion. Okay. So when one brother separates from the rest, there is no presumption that the others remain joined. Such an intention must be proved like any other fact, and we have seen that what happened, who has to prove it. The burden is on the party, as we have discussed, that who asserts the existence of a particular state of things, who is trying to say that no, there is no such thing. That is the particular guy. That is the person whom the court will ask to prove it. Okay, on the basis of, we can say, on the basis of which he claims the relief. Is it clear to you? Okay. So the effect of the partial partition may be summarized as follows as regards the partial partition to the property where the co-partner divide the joint property with the exception of a portion of it, where in the absence of indication to the contrary, tenant in common with reference to the accepted property, but where the partition is partial, not in respect of the property, but in respect of persons making it. It has been held by a series of decisions that the remaining co-partners, without any special agreement among themselves, may continue to be co-partners and enjoy as members of joint family the remaining property, and the question whether or not they continue to be joint or separate is to be determined on the evidence in each case. Okay, so this is what we can say summarized, and this is what we can refer with the things in regards to the effect of the partition. So we can say that apart from it, when I'm trying to conclude partial partition or the partition which we have taken, the full partition in its larger sense, what we can say, consists in a division of which the share of each co-partner with respect to all or any of the joint family is fixed. Okay, and once shares are defined, the partition in sense of the severance of status or disruption of joint family status is complete. But after the shares are so ascertained, the parties might elect and either to have a partition of the, we can say, the status of meets and bounds which we have discussed, which means the actual division of property, or to continue to live in together and enjoy the property in common as before. So whether they did one or the other will affect the mode of enjoyment, but the tenure of the property or interest in it, which we can say, there is a situation where the joint ownership has been turned into a joint possession and enjoyment until the physical partition. So the partition is having its own effects, and we have discussed in length in the lecture number 32 itself, where we have seen the physical partition and how this physical partition takes place. So the name of the shares, the date of the severance of the status are the important elements which constitute the facts. The moment the intention was communicated. So in short, also we can say partition by meets and bonds means the physical division of joint family status. So this completes the concept of the partition. So next class, I will be starting the what we can call the reopening of the partition and reunion. These are the two topics which are left for your third module to end, and this will cover your third module, reopening of the partition, which is again is not a very big topic. I might have started, but the time is going on. I want to have a fresh class, so it is okay for today that we completed a particular concept of partial partition in this particular class. In the next class, we may again start with partial partition if time permits, reopening of partition. And if time permits, we will try to see reunion also. Reunion are it's having two impacts. Who may do the reunion or who may reunite. And the second is that effects of such reunion. What are the effects of those reunion? So these are the two concepts which we have to see under the title of reunion. Okay, and again we have to see the reopening. So let's see, time permits. Tomorrow I will try to cover both the topics, or we can take one by one, whatever. So now, to be on a safer side, dear students, we have completed, after we will be finishing this particular partition, we would be completing 2/3 of a syllabus. 2/3. One, we can say, module will be left, in which we will be discussing the Hindu Succession Act 2005. There are interstate succession and succession to the Hindu male, and there is a class which we have to discuss. That is not a big deal. And after that, we shall start the Muslim law. In Muslim law, there are 4 modules, as I told you. So probably what I feel that in 35 to 40 lectures, probably, because today I am recording for 33rd lecture. So probably near something 40 we will be covering. I suppose this is my presumption. The first time I am doing it, so what I can say that I am assuming that somewhere near 40, it may be 1 or 2 less or 1 or 2 more. We will be covering, we will be able to complete the concept of Hindu law. And Muslim law, as I told you, there are 4 or 5 whatever modules are there. It won't take much time because they are not so long. Only there are few case law by which we have to analyze the thing. And as I told you that the Hindu law has been codified, and therefore there is a difference. The Muslim law is carrying on. There is no such thing. So this is for today from my side, and I hope that everything is great at your end, and you people are taking the precautions and whatever has been told to you, which is very much important. Apart from that, what I am trying to say that after we complete reunion and reopening, I suppose that this will cover, this will suffice rather for your midterms also, because majority of the things we will be discussing till 35th lecture. So if the other class is able to cover to this particular point, they will be covering it, no doubt, because they are just behind us, they are at par us. And if I stop recording for a few days, for say 3 or 4 days, they will cover us. So this is what I was planning. And after we have completed the concept of succession, if time permits, I will give you a break so that you are able to revise the things for your midterms. I may continue. Maybe if time permits me, I will try to upload it, or rather I can upload for after the midterms the remaining portion of Muslim law. I will try to cover till Hindu law. Let's see what is the scene, because I am also part of the admission committee. And when the admission will start again, it will be difficult for me to give time to the recordings, because I have to prepare. It will at least it takes 1 to 2 hours I have to give for preparation. Then recording of the lecture is there. 2 to 3 hours is required in one single recording. Maybe it is of 30 minutes or 40 minutes or 50 minutes, whatever. So let's see. But what my focus is, okay, my priority is to complete the syllabus for you for your midterms, and then we can have a break or whatever. So midterms will be starting from mid of what you can say after the Shara. Suppose the Shara is on 25th. So after that, it would be starting just after the Dashara. And I suppose you would require at least 1 week or 10 days prior to it so that you are able to focus on it. Whatever, because we are at par and we would be covering the syllabus on time. So there's nothing to worry. You will be having your exams the month of December. Okay. So thank you for your patient listening. I hope everything is great. Thank you. Have a nice day.